For judgment, item 1.
RFA 53 of 2023. Yes, this court has considered the submissions made by both the parties and finds no grounds to interfere with the judgment and order of the learned trial court. Accordingly, the appeal stands dismissed and disposed of.
My lord, I seek your lordship's indulgence in making a mention of unlisted item. It's a criminal petition number 3 of 2026. My lord,
What's the urgency?
the urgency is it's the Zimanama for release of seized currency. My lord, the one FIR, your lordship have disposed it before. So it has to be laid before your lordship.
What FIR was that? FIR was squashed or what?
No,
Then?
bail application was already filed and your lordship has disposed it before.
Disposed it by granting bail or?
Yes, granting bail, my lord.
Okay, we'll list it. Maybe in the next week on Monday.
Yes, my lord. Deeply obliged. I will submit.
For motion, item 2.
My lord, this is a case regarding the non-implementation of the Mizoram Counting of Past Service rules in favor of the petitioner's hearing. We were working under the government of Mizoram as a medical doctor. In the year 2008, we have been engaged as medical officer on officiating basis. Now, in the year 2013, we were regularized under grade 3 of the Mizoram Health Service rules. Thereafter, we were promoted in the year 2019 under grade 2. Now, to be promoted from grade 2 to grade 1, the qualifying service is 8 years. Now, if we have been given the benefit of this Mizoram Counting of Past Service rules, which is 1 year, 7 months, we have rendered service as officiating medical officer for a period of 5 years. And if 1/3 is counted as per the rules, 1 year, 7 months, we would have been qualified to be considered for appointment from grade 2 to grade 1 on 25/12/2026. Now, if that is not considered, we would be qualified, we would have the qualifying service only in the year 2027. So our past service rendered as officiating service has not been recognized by the state government. Your Lordship,
No, wait, let me try and understand you. Now,
Yes.
the Mizoram employment counting of past service rules.
Yes, ma'am.
Okay. You're saying as per these rules,
yes,
what? 1/3 of your
1/3 of
previous
the service rendered
service rendered.
as officiating
Okay, can be counted.
counted. We have rendered service as officiating for a period of 5 years, and if 1/3 is counted, there is 1 year, 7 months. So
Okay.
we would have been qualified to be
Eligible
considered
for qualification
in the year
from grade 2
to
to
grade 1
grade 1.
in December 25, 2026. So at this stage,
So have you made a representation?
yes, we have made a representation, but that representation has not been considered.
Till
And-
date.
yeah,
Where's the
no.
representation?
In fact, Your Lordship will see that there is a DPR comment which we have challenged in page number 65.
65.
So that is the reason we have also come before this court.
Okay, so you are sailing page number 65. What
That
does
is
it
the,
say? Please
I'll read from para 2, my lord. The doctors were already promoted from grade 3 to grade 2 of MHS prior to the date on which the Mizoram government employees counting of past service rules 2020 came into effect. Therefore, the benefits of counting their past service cannot be extended to them in view of Rule 5 of the said Rules 2020 and Para 2 subclause 3b of OM dated 22.
What does Rule 5 say?
Now, Rule 5 says, I'll take you to the rules, counting of past service rules, my lord.
Page?
Page 61. One part of the past service rendered by a work charge, contract, provisional, or any ad hoc officiating employee, here we are officiating employee, as specified under Rule 2 of this rule, shall be counted upon regular appointment to the same substantive sanction post in the feeder post grade as regular service for the purpose of determining eligibility for promotion to the next higher post, including promotion to the limited departmental examination, unless otherwise expressly provided in the relevant rules. Now, my lord, there is a notification issued by the Secretary to the Government of Mizoram. We'll also see that at page 56. It is concerning the present petitioner. Now, I'll come straight to para 2. As provided under Rule so and so of the Rules 2020 notified dated 25/2020 and published in the official Gazette right issue number so and so, 1/3 of the past service rendered on officiating basis shall be counted as regular service for the purpose of determining eligibility for the purpose of leave, promotion to higher post grade and deputation. So this has favored us. However, in spite of this, the government has rejected our prayer for consideration for our promotion from grade 2 to grade 1.
Okay, will you show notice?
My lord.
Let's see. So the impugned order is at page 65.
Yes, my lord.
Yes. Heard Mr. Lal Fagzwala, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ or order to the respondents by assailing the what is this? The notes. 65 is what? Notes. There's no.
Comments and notes.
Okay, assailing the comments dated 26th June 2025, wherein the petitioners were not granted to
One part of
granted
their
to
service.
consider their consider where were they appointed, their appointment on officiating basis prior to their promotion from grade 3 to grade 2. Is it?
Grade 2. They were promoted
From
to
grade 3 to grade 2. No, on officiating basis on 26/09/2008, prior to their promotion from grade 3 to grade 2. Full stop.
There are two appointments in officiating. One is 26 September, another is 1st October 2008.
Okay, 26/09/2008 and 1/10/2008. Okay. Prior to their regularization under grade 3, within brackets, junior grade, of the Mizoram Health Service.
Grade 3.
Grade 3 I've mentioned, okay,
Yes,
of the
madam.
Mizoram Health Service. The Learned Council submits that as per the Mizoram employees, within brackets, counting of service, close bracket rules, 2020. The rule provides for determining qualifying service to consider the period wherein the petitioners were appointed on officiating basis. Is it correct? Officiating
The
basis,
1/3 can be counted.
wherein 1/3 of the period is to be counted.
Period rendered as officiating.
1/3 of the period rendered on as officiating basis is to be considered for the required qualifying service of 8 years for promotion from grade 2 to
grade
grade
3. Grade 1, sorry.
2 to grade 1.
Grade 1,
isn't it?
grade 2 to grade 1.
Also. Then the Learned Council further submits that the impugned notes, is it?
Yes,
What was
Madam.
the
Notes and comments.
and comments dated 26/06/2025 is also not in accordance with the notification dated 21/06/2023 issued by the respondents, wherein the state respondents had permitted the competent authority to allow the counting of 1/3 of past services rendered on officiating basis as permitted under the Mizoram government employees within brackets counting of past service close bracket rules 2020. Thus aggrieved by the notes dated 26/06/2025, the petitioners have filed the instant writ petition. Full stop. On hearing the submissions made, this court finds it appropriate to issue notice of motion to the respondents. Full stop. Then a new para, Ms. Vane Isyami, learned government advocate, accepts notice on behalf of the state respondents.
1 to 5.
1 to 5. Anyone else?
6. Notice has to go to.
Okay, no need to issue formal notice to respond to the state government. Full stop. Notice be issued to respondent number 6 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Full stop. Requisite extra copies of the writ petition to be duly furnished to the Learned Council for the respondents, state respondents, to the Learned Government Advocate, okay, for the state respondents. Yes.
Obliged.
For omission. Item 3.
Yes.
Lordship, the steps against the respondent number 4 has been completed, and the office note indicate that there is
Oh,
no return.
2. We are still waiting for 2.
Waiting for 2.
2, and you have to also ascertain the proper address of respondent number
Yes,
3.
we need to find out the proper
Okay, so
address of-
wait for further time.
Yes,
isn't it?
yes.
Heard Mr. Roshan Subedi, Learned Counsel for the appellant, who submits that return of service of notice upon respondent number 2 is still awaited. Full stop. He also submitted that he may be given time to ascertain the correct address of respondent number 3. In view of the above submissions, place the matter again after 4 weeks.
Yes.
Okay. Good stuff. Then, in the presence of Mr. Atlan Lima, Learned Counsel for respondent number 1 is noted. Yes.
I'm okay.
Item 4.
Lordship, in this case, the respondents has been represented.
This is what, okay. FAO, isn't it? So, service of notice by way of speed post within 3 working days. So, if you wait for return of service of notice, is it?
No, Lordship, the
Then-
respondent has been represented by Mr.
My lord, I am for the respondent.
Sole respondent?
Yes, my lord.
Lordship,
So what do we have to do? Do we have to call for the
TCR.
PCR?
Yes,
Is it
Lordship.
required? It's
Yes,
required?
Lordship, required.
Okay. Ms. So-and-so, learned counsel for the appellant is present along with Mr. Yes,
Arnold Rothfeller, my lord.
Arnold Rothfeller,
Yes.
learned counsel for the sole respondent. The learned counsels submit that the TCR is required to be called for. So, in view of the above, TCR to be called for. List the matter again after 2 weeks?
Yes, Lordship.
2 weeks.
Deeply obliged.
Item 5.
May I please your lordship, my lord. In this appeal, the sole respondent is the son of the appellant, and
Son of,
Yes,
so,
son of
okay,
the
so
appellant.
father and son.
mother
Okay,
and son.
mother and son.
Yes,
So-
appellant is mother of the
So
sole
can you
respondent.
attempt to come to some settlement?
My lord,
Okay. But we have to issue notice first.
yes, yes.
You are the mother or the son?
Mother,
Okay, you're the mother.
yes, mother appellant. Sole respondent is the son.
What's happened between mother and son?
Oh, my lord. So,
Biological son?
yes,
Or stepson?
biological son. Yes,
Then settle your matter.
Yes.
Don't come to the court, isn't it? Okay, you are 73 years old.
yes.
Anyway, we'll issue notice first.
My lord.
Then I think the matter is appropriate to be referred to mediation.
Yes,
They're fighting over some property.
yes, yes.
Who is residing in the property?
Both
Both of them. They're
Yes,
staying
yeah.
together and they're still fighting.
under same LSC, but on different buildings.
Anyways, let's see. We'll issue notice first. Heard Mr. Lalam Tonga, learned counsel for the appellant who has filed the instant appeal under section 17 within brackets 2 within brackets small b of the Mizoram Civil Courts Act, 2005, read with order 43 rule 1 of the Civil Procedure Code for setting aside the impugned order dated 01/12/2020 passed by the learned senior civil judge dash Roman 3, okay, comma, ISOR in issuing the airship certificate number 1150/2020 to the respondent. Appeal is admitted. Issue notice to the sole respondent through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
That's all.
Item 6.
My lord, in this matter, I've been appointed as a legal aid counsel by the High Court Legal Services Committee to represent the sole respondent.
But no one's appearing for the petitioner, isn't it?
Yes.
None appeared for the petitioner on call while Mr.
Hitlan Tiang Lima.
Tang Thiam Lima, learned legal aid counsel, submits that he has been appointed to represent the sole respondent. Good stuff. Since none appeared for the petitioner, matter be listed again after 2 weeks.
3 weeks, my lord. If I may have the liberty to file objection
Okay,
to the
after
revision petition, my lord.
3 weeks. Meanwhile, the Learned Legal Aid Council may file his written objection, if so advised.
I'm obliged.
4 orders. Item 7.
Lordship, I'm appearing on behalf of my senior, Mr. Johnny L. Tauchong. He took leave today due to personal difficulties, my lord. So if this matter can be taken up on next week.
Okay. Who is for the respondents? Notice,
Yes, my lord, the notice were completed, but
newspaper
however,
publication.
yes, my
So
lord.
notice upon respondent number 3 is complete,
Yes,
isn't
my
it?
lord.
Then who are the other respondents? None appeared?
Yes, my lord, they have no representative yet.
Okay. Heard Mr.
Dalmang isang.
Lalpanga Isyanga, Learned Counsel, appearing on behalf of his senior, Mr. Johnny L. Tauchong, Learned Counsel for the applicant, who has prayed for adjournment of the matter on the grounds that the senior is on legs, is it?
Yes, my lord.
In the other court. Good stop. It is seen that none appeared for the respondents. In view of the above, list the matter after 2 weeks.
Okay, my lord.
Okay, after 2 weeks.
Much obliged.
Item 8.
My lord, notice upon the respondent number 2 is still awaited, my lord. I'll
Who
have
appears
to
to be
seek instructions, my lord, regarding this because we have to take Ministry of Home Affairs approval and all those stuff. So that will take time.
What is the seized amount for which he was acquitted, it appears? Taking it very seriously, what is the seized amount?
It's a commercial quantity, my lord, and the amount. Of 3.100 kgs of methamphetamine.
Methamphetamine.
Yes, ma'am.
So the market value of 3.1 kgs will be how much? Anyways, you can chase after him. It's okay. Okay. Heard Mrs. Linda L. Fumble, Learned PP, who has prayed for further time. To take necessary steps for issuance of notice to respondent number 2. In view of the above, as prayed for, list the matter after 4 weeks.
Yes, ma'am.
4 weeks, full stop. Then the presence of Mr. Lalbiak Nunganamte, Learned Counsel for respondents number 1 and 3 is noted. Yes.
Item 9.
Yes, Your Lordship, this is a criminal appeal filed against acquittal order and appears to respondent number 1 is
Service
still
report.
awaited. Yes,
Return
Your
of
Lordship.
service. Then we'll wait for some more time.
Yes, Your Lordship.
Ms. Bani Isyami, Learned Additional PP for the state applicant is present. It is seen that return of service of notice upon respondents number 1 and 2 is still awaited. In view of the above, is the matter after 3 weeks.
Obliged.
Item 10.
Yes, may it please your lordships. Lordship, I'm here for the appellants. And my lord, as per the last order dated 12 to 20,
Newspaper
2025.
publication.
Yes,
So you
and-
have it here?
Yes, my lord.
This is with regards to service of notice upon respondent number
1 and 6, my lord.
1 and 6. Ms. Lal Nomsang, Learned Counsel for the applicant is present. No, instead of is present, heard Miss so-and-so, learned counsel for the applicant slash appellant, who submits that notice upon respondents number 1 and 6 has been served through newspaper publication, and affidavit to that effect has been filed. Stop. The new para, this court, on perusal of the affidavit, finds that newspaper publication was made by was made which newspaper? You should give the heading. We don't know which newspaper is this.
Vanglini and Isopos, my lord.
Then that should be there, no? Not only this page, which newspaper we have to know, the date also we have to know. You have just given this little thing. Okay.
Yes, my lord.
The newspaper, the main heading, and then the behind page, this. Okay. Newspaper publication was made in, see, how do I know what newspaper, date, nothing. No, we cannot accept this. It has to be there, okay? Because other newspaper publications, they always show, not only this. Okay? Wait, this is Lomsani, learned counsel, waiter, learned counsel submits that she may be allowed to enclose the proper document in the affidavit to show that newspaper publication was duly done in terms of this court, done for issuance of notice, okay, in terms of this court's order dated 12/12/2025. Praise the Lord. List. When can you give this? In the next week?
Next week, my lord.
List in the next week. Okay, good stuff. The presence of Miss Caroline K. Landungonpi, learned government advocate for the state respondents, is noted. Yes.
Item 11.
You just enclose this in your affidavit. No need to file any of this thing new. Okay, I think registry, just make note. That should be there. Yes.
If your lordship, this is an application for condoning a delay of 2,552 days. However, the delay is due to the fact that the applicant is a minor when he gained knowledge and he had recently attained majority. So the
Court title. What? So
the actual delay is only 325 days, my lord. Because he had no knowledge, an heirship certificate was obtained by his uncle behind his back when he was only a child. That is the problem.
no. Okay, you explain that. You
Yes, yes.
explain that later. Okay, in the hearing. Yes. Have you filed your this thing, written objection?
Not yet, Lordship. We will be finding if I may be given time. 3 weeks' time, Lordship. if possible.
Why? Objection. His line of this thing, argument is going to be that when he attained majority,
Yes,
only
Lordship.
from there it has to be counted. So you read up on that point.
Yes,
Okay.
Lordship.
Yes. I don't know whether that would be the correct line. Anyway, heard Mr. Zoram Thana, learned counsel, make it Mr. Zoram Thana, learned counsel for the applicant is present, along with Ms. So-and-so, learned counsel for the respondent. Full stop. The learned counsel for the respondent has prayed for 2 weeks' time.
3 weeks, Lordship.
Okay, 3 weeks' time to file their written objection. In view of the above, list the matter after 3 weeks.
Deeply obliged.
Obliged, my lord.
Item 12.
Same, yes.
May I please, Your Lordship? My Lord, we are seeking impleadment of new respondent, upon the transfer of the respondent number 2 in contempt case number 24 of 2025. Since the respondent number 2 has been transferred to Guwahati, so the new incumbent officer has to be replaced. I mean, has to be impleaded.
And so
As
a fresh impleadment. So he will be respondent number
8.
8. But in the application, you've made it wrong. That part you know, isn't it? So I will not dismiss here this thing. I will consider, I will allow. But next time, whenever you file an impleadment application, the next number has to be used, okay? Because here you have mentioned striking of the name. When the contempt petitioner was filed, he was still the petitioner, so he's there. But then a new person will be impleaded. We'll allow. Heard Miss So-and-so, learned counsel for the applicant who has filed the instant application under Order 1, Rule 10 within brackets 2, CPC, 1908, read with Section 151 CPC for impleading the new incumbent, Shri Sanjeev Dawa, as respondent number 8 in the connected contempt case number 24 of 2025 on the transfer of the previous incumbent Shri Girish Prasad Singh, arrayed as respondent number 2. Issue notice, Miss Baby so-and-so accepts notice on behalf of the learned CGC representing respondent number 2 and Mr.
Daniel Shasel.
There's appearing on behalf of his senior Mr.
Miss Mary.
Okay, Miss Mary so-and-so, learned government advocate for the state respondents. Stop.
Oh, Miss
The
Your Lordship, for respondent number 6.
Okay, for respondent number 6, not state respondents, it's just a contempt for respondent number 6. Stop. The learned counsels for the respondents submit that they have no objection to the instant interlocutory application. Stop. In view of the above, this court find it fit to allow the impleadment of Shri Sanjeev Daw, comma, what you see? Sanjeev Daw is what? What is his post? Sanjeev Daw to implead.
He's the chief engineer.
Oh, you should mention that also,
Border
isn't it?
Task
Sanjeev Daw, page what? Where do I have to see? Okay, Sanjeev Daw, comma, chief engineer, comma, project Pushpak, comma, border road task force, within brackets, BRTF, close bracket, comma, care of 99 APO, comma, Twampui, comma, Aizol, dash 796017 as respondent number 8 in the connected contempt case number 24 of 2025 on the transfer of Mr. Girish Prasad Singh / respondent number 2. Stop. Yes, then accordingly, IA number 36/2026 stands allowed and disposed of. Stop. Then close. Then in the main contempt petition, okay, on the disposal of IA number 36/2026, allowing the impleadment of respondent number 6, again the name, okay, so-and-so. The learned counsel for the petitioner is to take, correct the cause title and thereafter issue notice to the newly impleaded respondent number 8 through registered post with AD returnable by no, AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Yes.
Part 2, item number 2.
What is this? Hearing part 2. None appeared for the parties on call. List after 2 weeks.
Item number 4.
Okay. None appeared for the same. Okay. List after 3 weeks. Oh.
Item number 5.
Anyone appearing? For any of the part 2?
Item
The
8, my
5
lord.
same order. Item number?
8.
8. 6 also same order. Okay. Then 8, Mr. Ladbiagnu.
My lord, I just want to make a small submission, my lord. If it may be taken up by next Tuesday, my lord, because
Okay.
ultimately my prayer here is I just want to adduce my defense evidence at the lower court.
Okay.
It is a simple matter.
The learned counsel for the appellant is present while none appeared for the respondents. In view of the above, as sought for, list on, what is the date?
24, my lord.
Next week.
Yes, Tuesday.
Criminal appeal.
Yes,
This is an appeal hearing.
yes, my lord. Appeal hearing.
Then,
I was convicted under Section 8 of POCSO Act, but my claim is that my explanation under Section 313, I believe that it was sufficient at the trial court. However,
no, that's not that simple. We have to write a full judgment. I don't have, okay, give a date, not during the month of February, during the first week of March, we'll fix a date.
any date is fine. my lord.
As sought, in view of the above,
Fifth
as
day.
sought for, list on 3rd, okay, 03/03/2026, okay,
It
yes.
be applies.
Item 9.
None appeared for the parties on call, list after 3 weeks. Or make it 2 weeks.